Go on to Colette Stafford.
Good afternoon, Judge. Colette Stafford, and I'm just a spectator.
Okay. There's next, I think it's Wooten. It says Wooten. I don't know who that is. Mr. or Mrs. Wooten, can you hear me? Unmute your microphone, please. Yes, not. Then we have Max Munoz.
I'm a spectator.
Okay. We've got one. Is this generally labeled audience? Who's that? How many are there? How about Sylvia Schultz? Computer indicates something's trying to happen on the audio feed, but we're not hearing any sound. So Sylvia Schultz, I guess, is present. DTC initials. If you can hear me, unmute your microphone and please identify yourself. Guess not. Sorry, sir, no microphone. So, how about Alicia Benford? Just Benford, unmute your microphone and.
Hi, Your Honor. I'm Alicia Benford. I'm a defense counsel, trustee, and executive director for the Autonomous Public Company.
Okay. How about Anna Calix? Ms. Calix, if you can hear me, unmute your microphone and identify yourself, please. Okay, I guess not. iPhone, it's just described as iPhone. I don't know who that is, but somebody's using that identification. Please identify yourself. One more time, because you might.
Sorry.
One more time. Okay, I'm sorry, the audio is just not coming through. How about Anna Calix? Ms. Calix, unmute your microphone and identify yourself, please. I guess not. Then the last one, I think I G8 Thin Q. Is that, who is that, please? From there, I think we're going to proceed. I know, Mr. Miles, can you hear me?
Yes, Judge, I can.
I think we're here today with respect to the motion to dismiss that you filed. I was looking through the file earlier. There was a response due by the 21st. Sometimes things are a little slow in getting to the file. Mr. Ivick, did you file a response?
I did, Your Honor.
All right. So, Mr. Powell,
I also sent courtesy copies to your email, Judge, and to the parties.
I hadn't seen those come through. Mr. Powell, go ahead. Relate the essence and substance of your motion. I understand that it's a motion to dismiss based on a jurisdictional issue over the proper service. Is that right?
Yes, Judge. You want to take the time and download his response and maybe take a minute to review it?
I'm going to see if I've got it here. Hold on a second.
Judge, this is Jim Rowe. While you look for that, I'm not sure if it would have made it into your file yet or not. Earlier today, we did not file a response to the motion to dismiss, but we did file a notice that we are joining in the motion to dismiss on behalf of the board.
Because in the schedule, it's like
Hold
See you soon. Right, bye. It's at 4, not 4:15. She said I couldn't get the appointment to go in there because she had you marked for a break at that time and I couldn't get to work. Maybe it's good. I don't know. But she said no, she'll be here.
Actually, I do have a petitioner's response. If you'll indulge me just a minute here, let me see what I've got.
Judge, that should be 5 pages, 2 exhibits, and then there's an attachment with all the case law and rules cited.
Right, so I've had an opportunity now to review the response provided by Mr. Ivick. Mr. Piles, go ahead and present your motion, then we'll have hear from you.
Briefly, Judge, electoral board cases that's a special jurisdiction that is exercised by the court in order to review an electoral board decision. Within the election code, the legislature has given the court the ability to administratively review electoral board decisions to make sure they're in conformance with the election code. In order for the court to have jurisdiction over an electoral board review, a judicial review of an electoral board decision, the petitioner has to do 4 things. 1, he's got to file his petition with the clerk of the court within 5 days. The second thing, he's got to serve copies of the petition on the board and other parties to the proceeding by registered or certified mail within 5 days after the board's service of his decision. It's got to state in the petition why the board's decision should be reversed, and you got to file proof of service with the clerk of the court. So in order for the court to have jurisdiction over the substance of the petition for judicial review, the petitioner has to do those 4 things. And the reason I wanted you to look at the response filed by the responding or by the petitioner candidate, as he admits in that response that he did not comply. He served the board members by email and regular mail. You're going to also notice on there that he claims that he served the objector, but he did not serve the objector. If you look at the proof of service that's attached to my motion, there is nothing to the objector, Richard Giron. He is not listed on there anywhere. Have received the petition for judicial review. Furthermore, he did not serve the board members by certified mail, which is what's required under the statute as well. And third, he's got to file proof of service that he did serve the objector and the other board members by certified mail, which he has not done. He filed the proof of service, but it doesn't indicate he did it by certified mail. According to the case that I cited in my brief, the court doesn't have jurisdiction because he did not serve the board members by certified mail. He didn't serve the objector at all. And as a result, the court doesn't have any jurisdiction. I mean, the case is over. If he doesn't serve people by certified mail, the petition for judicial review, the court does not have jurisdiction. Now, I believe the attorney for the Electoral Board has joined my motion, and he agrees with this reading of the petition of the election code. Now, the candidate has filed a response that raises, I believe, 3 separate issues. Number 1, he says that he did serve the objector because he sent an email and regular mail service to his attorney, me. Now, the cases are pretty clear. I'm going to quote from the Quinn case, which is cited in my brief, and I'm going to cite from, it's going to be, I believe, on page 4 at the top of the left. Quote, however, on at least 4 separate occasions, courts have recognized that service upon an attorney is insufficient to strictly comply with section 10.1's requirement that service must be made personally upon the electoral board and the other parties to the proceeding. And it cites the statute and it cites several cases. While proponents attempt to distinguish this authority in various ways, the court has made it explicitly clear that in the context of election cases, service to a party's attorney, rather than to a party personally, is entirely improper under the code and directly violates section 10-10.1. Really, not much of a discussion is needed on that point. 2015 case of Pat Quinn versus the Board of Election Commissioners for the city of Chicago. That case was dismissed for lack of jurisdiction, and if it's good enough for the former governor, it's good enough for Mr. Munoz. As to the second issue raised, that it was good enough to serve by regular mail, I quote from the Bay case, which is also cited in my brief, and the candidate goes to great lengths to state that there's ballot access and so forth. But the Bay case, which is in 2015, its quotes on page 6, the last page in the right column. While access to the ballot on the ballot is a substantial right, not lightly to be denied, that concern does not undercut the strict compliance with Section 10-10.1. Explicitly required by the Supreme Court in Bettis. Plaintiff failed to send his petition for judicial review by registered or certified mail as required by statute and thus lacked jurisdiction to hear it. There's really not really much room here because the candidate did not serve his petition for judicial review by certified mail to the board members, and he didn't send it to Mr. Girard at all. And furthermore, he didn't file the appropriate proof of service indicating he did those things. So, he violates two sections of the 10-10.1, and the court, because he did not comply with the requirements, there's simply just the court doesn't have any jurisdiction. Thirdly, the candidate raises the COVID-19 pandemic as a reason for the court to excuse his not filing the certified mail. And to me, the cases that he cites were lowered the signature requirements for independent and third-party political candidates, and some of the alterations to the signature requirement. That doesn't really apply here. What the district court in that case was trying to do is limit the person-to-person contact of people during the pandemic from going door-to-door and getting signatures. The COVID-19 didn't really cause any inconvenience to the candidate here. He sent to the board members, at least, he sent by regular mail. All he had to do was slap the green card in the back of the envelope to do it by certified. And he didn't do it. I don't know what COVID-19 emergency has anything to do with that. Frankly, the candidate, his petition, the court doesn't have any jurisdiction to hear it. Now, the candidate cites a United States Supreme Court case from 1940. Well, that might be well and good, but the Bay case from 2015, the Illinois Supreme Court case from 2014, and the Quinn case from 2018, that 1940 Supreme Court case and the Federal Circuit Court cases that he cites for persuasive authority about registered mail, they don't have any application here. That's talking about whether or not somebody's got actual notice. I'm talking about a jurisdictional requirement for this court to hear the petition for judicial review. That procedure was not followed. And under the cases that I've cited that are from this decade, the court doesn't have any jurisdiction to hear it, and the case should be dismissed. Thank you.
Mr. Iver. Mr. Iver, you're muted. Please unmute your microphone.
Your Honor, Mr. Rowe is also joined in. I don't know if he has any additional arguments, so I can respond to both.
Mr. Fry, I'm sorry, I'm getting a little bit ahead of myself. Mr. Rowe?
Judge, I would just join in Mr. Pyle's motion on behalf of the board, as well as his arguments. The statute seems pretty clear here. There's a requirement of strict compliance, and that clearly has not been met by Mr. Iden. Mail needed to come certified or registered. It came regular mail, violates the statute. Pursuant to the cases Mr. Piles has argued and cited in his brief, matter should be dismissed. The court lacks subject matter jurisdiction.
Mr. Ibeck, what do you want to say?
Thank you, Your Honor. First, I did receive the written response from the board joining in. Judge, I didn't have an opportunity to file a written response, but I think we gave the same arguments, Judge. Judge, with regard to all the cases cited by Mr. Piles, they have one thing in common. None of them were dealing with a global pandemic. Not a single one of his cases were cited under this unique situation. Judge, we're all on electronic, device right now, Zoom. We're not in front of Your Honor. Completely different, Judge. I think that is very relevant. The petition, or the objector, Judge, does not contest actual notice, does not contest the content of the petition. He's contesting the form of service. He's valuing form over substance, Judge. And while I do agree with him that we do have some cases that do say that, none of those cases were during this type of circumstance that we currently are under. Judge, the fact that COVID-19 has completely upended our system is evident. Judge, I think I cited the Northern District case, Libertarian Party versus Pritzker, because that's an election case under this circumstance. Okay? In that particular case, Judge, in order to get on the ballot, there by statute are requirements. There's no provision to change it if there's a pandemic. There's no provision in the statute to lessen the number of signatures. The court lessened the signatures by 90%. There is no provisions in the statute to allow email signatures. The court allowed that as well, Judge, because the court felt the need to balance the statutory, what's in writing, Judge, with people's due process rights and the right of ballot access. That was a very important right that the court realized that this isn't the normal circumstance. The court wasn't bound by what was written in the code, because what was written in the code due to this circumstance would violate ballot access and would violate due process, Judge, violate the people's rights. Judge, that's very much our case here. Judge, the question, I think, is what is the intent of Section 10.18? That's where this court gets jurisdiction. Okay? I think Mr. Piles is absolutely right that Bettis versus Marsalia is a Supreme Court case dealing with what gives this court jurisdiction. And in Bettis versus Marsalia, the court said, our overriding purpose in construing a statute is to ascertain the legislative intent, and the obvious intent behind Section 10.1a is to ensure that all necessary parties receive notice that a petition for judicial review has been filed. Judge, that purpose has been fully accomplished in our case. Judge, I note that Bettis also talks about the access to a place on the ballot as a substantial right, not lightly to be denied. The court re-emphasized that, Judge, and I think turning to the situation that we're in, Mr. Piles would have you deny that right and deny the intent based on a form, not on substance, because he's not saying he didn't get actual notice. And he would deny that right when we fully complied with local rules and the Illinois Supreme Court. Judge Shainstead issued a series of administrative orders that are binding on us. And there was a reason for it, Judge. He was, whereas the COVID-19 pandemic has resulted in deaths and illness to thousands of individuals around the world, prompting federal and state declarations of emergency. Whereas the health and safety of the public, court employees, and all others doing business in the judicial facilities and the 12th Judicial Circuit is of paramount importance to the court. Whereas the court should employ all reasonable measures to reduce the need for large gatherings in order to protect the public, court employees, and those doing business in the court facilities in the 12th Judicial Circuit. Whereas the Chief Judge has administrative authority to enter orders setting forth the docket and schedules of cases pursuant to Supreme Court Rule 21. Whereas on May 20th, 2020, the Supreme Court amended its order of May 17 and further provided written guidelines to be followed by the Chief Judge and court facilities and services begin to resume. And whereas the Chief Judge of the 12th Judicial Circuit has issued administrative orders 2020-08, 09, 10, 11, 12, 13, 14, 15, 16, 19, 20, and 21, it is hereby ordered that all cases within the 12th Judicial Circuit are hereby subject to the terms of this order. That includes this case, Judge. This case is subject to this order. And the order was entered, I'm quoting from Rule Administrative Order 2020-23, which was filed on May 27th to be effective June 1st. With regard to civil cases, which is paragraph 6, it includes miscellaneous remedies, which is one of what this case is. And it says, paragraph 6C, all cases, including motions and pleadings, may continue to be filed pursuant to Supreme Court rule. All parties are encouraged to file documents with the court electronically. Judge, the rule in the Supreme Court is Rule 11. Judge, Rule 11 states, one second, Your Honor. Judge, Rule 11 states, and it was recently amended. Judge, it was recently amended to make it even more important to do email. It used to be self-represented litigants had the option, didn't have to give their email addresses. Now they're required, if they have an email address, to provide it. But Rule 11 talks about manner of serving documents. Judge, it says, on whom made. If a party is represented by an attorney of record, service shall be made upon the attorney. Otherwise, service shall be made upon the party. It also talks about method that if, Judge, that there was some other means, such as a court order that said that you had to serve some other way, Judge, or if there was a statute that says you have to serve some other way. It says, if service of other than electronic service is specified by rule or order of court, or if extraordinary circumstances prevent timely electronic service in a particular instance, service of documents may be made by one of the following alternative methods. And it lists 4 methods, Judge, and number 3 is United States mail. Depositing the documents in the United States Post Office or Post Office box, enclosing an envelope to the party's address, as identified the party's appearance in the matter, with postage fully prepaid. Judge, in our case, we fully complied. Judge, we were encouraged and told by our local rule to do things electronically as far as we could, Judge. And we were also told that we can proceed with civil cases as provided by Supreme Court rule. Supreme Court rule states that if there is an attorney of record, we serve that attorney. And it also says if there's any other rules, we can serve by U.S. mail. In this case, I don't think there is any, they're not contesting that they didn't receive the email. They're not contesting that they didn't receive it by U.S. mail. They're saying, well, we didn't follow this pre-COVID-19 plan that talked about method over manner over substance, Judge. Judge, I think with regard to whether Mr. Piles is the attorney of record, Judge, I would like to point out the fact that this case, 2020 MR 1256, existed prior to this particular pleading. That we had filed an emergency petition for judicial review, that on June 18th, Mr. Piles appeared on that date before this court. He identified himself to this court as the attorney of Mr. Gerard, orally. He then argued on behalf of Mr. Gerard. And then after the court rendered a decision, and this is my Exhibit A, Judge, that's attached to it, he prepared a draft order. Judge, in the draft order, on the very bottom, it says Scott Piles with his ARDC number, and parentheses, attorney for petitioner objector. and then his address misfirmed. And so Mr. Piles has previously identified himself as the attorney for the objector. And Judge, it is mandatory, it's a shall be made upon the attorney. We're in a unique situation, Judge, where this particular, besides the COVID, we were already before the court on this motion, Judge, for judicial review. And Judge, since Mr. Piles appeared and argued and identified himself as the attorney, for me to serve notice on his client is improper. The Supreme Court rule says I shall serve it upon the attorney who has appeared. He's already appeared. Judge, the fact that he didn't file a written appearance before he spoke or immediately after doesn't change the fact that he identified himself. I'm the attorney for Mr. Gerard, and doesn't change the fact that he is the attorney of record. Judge, consistent with these extraordinary circumstances, the board themselves wanted to deviate from the rules for service. At the last day, when they made their decision, Judge, holding that Mr. Munoz shouldn't be on the ballot, they had prepared acceptance of service by email that they had for both the petitioners and the respondents, Judge, both the candidate and the objector. They asked both parties, would they waive personal service and the service that's required by statute and accept service by email? Judge, there's no place in the statute that allows for that. There's no place that says, well, you can do it some other way. Again, Judge, we're in an extraordinary circumstance where we're trying to keep people safe, Judge. We're not trying to get people sick. And from the Bettis case, the intent is notice, Judge. And I signed the waiver on behalf of Rick Munoz to accept it by email. Mr. Piles signed on behalf of Objector Richard Gerard to accept service on behalf of Mr. Gerard via email. Judge, I personally asked the board members for their email addresses and their attorney at the time, so I could give them the service the way they wanted the service to be sent. And they all gave me their emails, and I sent them the emails. And again, Judge, that was done in open court, and I emailed that to them. Judge, I think as we're looking at this, I think it's important to understand what we're talking about. Okay, ultimately, both the board and the objector aren't arguing that they had actual notice. They aren't arguing that the intent was followed. They're arguing that they got something by email and by U.S. mail rather than registered mail and rather than certified mail, Judge. I cited a bunch of cases, Judge, that I think are helpful. Judge, Illinois case, Roll versus Gorkopoulos, that talked about a provision requiring sending by notice by registered mail is merely intended to ensure delivery. Judge, that was in the context of a lease. Judge, in the context of jurisdiction, subject matter jurisdiction, I cited the U.S. Supreme Court from 1940, Flesher Engineering versus U.S. for use and benefit of Hallenbeck. Judge, in that case, jurisdiction for the Miller Act required it service by, in writing, registered or certified mail. The person failed to give the proper written notice. They gave U.S. mail, Judge. And in that case, the court held that the purpose of the provision as to manner of service was to assure receipt of notice, not to make the prescribed method mandatory, so as to deny the right of suit when written notice within the specified time had actually been given and received. And here's interesting, Judge. The Supreme Court says, it is not reasonable to suppose that Congress intended to insist upon an idle form. Mr. Piles would have this court insist upon an idle form. He's not saying he can get an actual notice. Okay, he wants this idle form. And Judge, the Seventh Circuit and the Ninth Circuit have had similar readings where they also talk about, not doing idle forms. Judge, in Hillsdale, it says, although Hillsdale did not meticulously follow the registered mail portions of the notice requirement outlined in 40 U.S.C. Section 270B, all relevant parties received actual notice within the time period. Based on analogous circumstances, other courts have often held actual notice is insufficient to fulfill the notice or accuracy requirements of the Act. Judge, I do agree with Mr. Files that we've had cases pre-COVID where this argument about the U.S. Supreme Court and that it's the method, not it's the actual service, not the manner that matters. And that has been rejected by courts in Illinois, Judge. But I think not since COVID-19 and not since this circuit court, the 12th Circuit, since Judge Shainstead changed, and emphasized he wants everything done by email. Okay? And when it says by administrative order that we are to, start new cases by electronically and pursuant to the Illinois Supreme Court rule, and when the Illinois Supreme Court rule, which has been modified to even strengthen that, says that if there is an attorney of record, I shall serve the attorney. Okay, and when it says that I'm supposed to do this electronically, Judge, we've fully complied. We've complied with the letter of the law. We've complied with the intent of the law, Judge. And I think any insistence on strict compliance as to manner of service in light of actual service places form over substance. I think it denies my clients their ability to ballot access. It raises First and 14th Amendments, Judge, when we comply with the changed circumstance that we're in. And they're saying, no, the fact that you followed what the Chief Judge was telling you to do, the fact that you followed the Supreme Court rules, again, it's kind of, disingenuous, Judge. Mr. Biles gave my client notice via email. Jim Moreau's client, the board, didn't comply with the requirements. They were supposed to give personal service of the objection. Okay? But they didn't. Okay?
I'm sorry, Mr. Rehandle.
Yeah, Judge, that's not me speaking Taiwan, whatever language that is. Judge, they didn't give the proper notice to start this. They posted on my client's door. Mr. Munoz did not receive certified registered mail. He did not receive actual notice. It was posted on his door. Okay? Again, we're in unique times, Judge. I don't think that deprived the board the ability to proceed. We had notice. Okay? We appeared. We were heard. Judge, everyone here, the objector and the board, has actual notice. They all previously consented to the use of emails in derivation to what the statute says, Judge. The statute doesn't say that they can give us notice of the decision by email, but we all signed that waiver and agreed to it. And again, Judge, I don't think this court is bound by cases that don't apply in the same circumstance, Judge. And I think you see that when how the Northern District dealt with issues that implicate constitutional rights. They went to 10% of the signature requirement. They allowed email signatures, not in the statute. They wrote that completely. Okay, and to elevate form over, substance in this, Judge, I think would deny my clients not only ballot access, not only implicate their First and 14th Amendment rights, Judge, it would deny everyone in Will County the ability to have a choice this election. Okay, and it's the same technical argument that they want to make. They want to say that we can't, somehow because we complied with the administrative order in the Illinois Supreme Court rule, that it doesn't comply with the past. Okay, this court has jurisdiction. I think this court, can understand that when the Supreme Court in Bettis says that the overriding purpose is to ensure that all necessary parties receive the notice for jurisdiction, all necessary parties have received notice. Okay? this, we have fully complied, Judge, in this circumstance, in these times that we have, and Judge, we'd ask for you to deny their motion for dismissal.
Mr. Files?
I'll be brief, Judge. First, the Rule 11 argument. If you had your Code of Civil Procedure there and you actually look at what Rule 11 is, Rule 11 is for a rule regarding manner of serving documents other than process and complaints on parties not in default in the trial and reviewing courts. That rule addresses people already in the case where there's a case ongoing in the service of motions and whatnot. Petition for judicial review is a new case. Rule 11 does not apply. There are statutes in place that show what the service of process should be when you are filing a petition for judicial review. And those are laid out in 10-10.1. Candidate's attorney admits he did not serve it by certified mail. He raises the COVID-19 and heard lots about how the pandemic has changed everything. Well, what I didn't hear, however, is how the pandemic changed the fact that all he had to do was to pay the $2 per envelope and make the regular mails certified mailings. I don't know how the COVID-19 gets in the way of that. All you got to do is slap the green card on, pay the $2 per envelope, and you got certified mail. I don't know how COVID-19 gets in the way of that. And we heard a lot about amending rules and so forth. I can tell you this, 10.10-1 was not amended and wasn't changed. And there's been no allegation by the candidate's attorney that it has been. There's been nothing that's changed the requirements that you have to serve a petition for judicial review by certified mail. I haven't seen anything that Judge Shainstead did that changed that. In fact, I didn't see anything that in any administrative order, Supreme Court rule that changes how complaints that are being filed are served on parties. There isn't any change to that. You still have to personally serve or substitute serve defendants in any sort of civil litigation. I didn't see any rule changes with regard to that. I don't really see how we get around this statute. The fact that I signed the acceptance of service of the electoral board decision by email, I don't know how that really does anything here. If you read what the candidate has attached to his brief, I agreed on behalf of the objector to accept service of the decision by email. I don't see anywhere in here where I agreed to accept the petition for judicial review by email on behalf of my client. Don't see it anywhere on here at all. And I've already been through, and the other difficulty that the candidate here talks about is I didn't really hear any discussion of the Quinn case or the Bay case that is cited that I quoted from during the argument. I didn't hear any discussion about those at all. I heard about 1940 U.S. Supreme Court case talking about registered mail. I didn't hear anything within the last decade on how the Illinois courts have strictly construed the jurisdictional requirements for a petition for judicial review. I don't know how the candidate gets around this. He did not serve it by certified mail within 5 days. If you look at the proof of service, the objector has never gotten any service of anything. Richard Girott's address, it's on the objector's petition. His address is on there. He could have sent a certified mail to the objector. His address that's listed on the objector's petition, it's not done. He could have sent, he didn't send an email either. Now, there was an argument made by Mr. Ivik that it would have been improper for him to serve Mr. Girott because I appeared earlier when he filed the case where the court had no jurisdiction. Well, that doesn't quite wash either, Judge, because if you follow that logic, then why did he serve the board members because Assistant State's Attorney Connor McCarthy appeared on behalf of the board at that same hearing, but the board members got served. I don't understand why the board members get served and not the objector if you follow that line of argument. Again, not helpful to the candidate. In fact, there's really no support at all for what the candidate is trying to say here, other than he says that the pandemic has caused, the relaxation of rules. The problem is that in this particular instance, there's been no change to 10-10.1. I hadn't heard any concern of why sending the envelopes by certified mail or registered mail due to the pandemic was necessary. I didn't hear anything about that. All he had to do, again, was put the green card on the back of the envelope. That wasn't done. The statute requires it to be done. And as far as the arguments about having actual notice, that doesn't make any difference in this argument. Illinois law is clear. He has to follow those 4 steps in order for the court to have jurisdiction. Let me repeat that. He has to do those 4 things. He's got to file within 5 days. He's got to serve by certified mail or registered mail. He's got to explain why the decision should be reversed, and he's got to file a proof of service showing he did the certified mailings. He didn't file the proof of service showing the certified mailings. He didn't serve anybody by certified mail, and he didn't observe the objector at all. And I think, frankly, to require, and by the way, the objector is contesting the contents of the underlying petition for judicial review. There was I didn't address that. We will address that. But frankly, given that the court doesn't have any jurisdiction to require the objector and the board to go to the time and expense to respond to the petition for judicial review when the court doesn't have any jurisdiction, I think adds unnecessary cost to the parties when simply the court doesn't have any jurisdiction. And the jurisdiction was lost when the candidates did not comply with the strict requirements of 10-10.1. And the Illinois case law is clear. Those requirements have to be strictly complied with.
Mr. Rowan, do you want to say anything?
Your Honor, I agree with Mr. Piles. I think that the court lacks subject matter jurisdiction. Mr. Ivick raised a number of arguments, but the argument Your Honor did not hear was that they complied with the election code. And when you look at the election code, it clearly says, must serve a copy of the petition upon the electoral board and the other parties to the proceeding by registered or certified mail. It simply wasn't done. And I think that when Mr. Ivick realized that upon the filing of Mr. Piles' motion, he realized that not only was that not complied with, but that error is fatal. It is fatal to Mr. Munoz's petition. It's fatal to the entirety of the case because then the court loses subject matter jurisdiction. So now we try to come up with explanations to explain away why the code wasn't complied with. And we can throw out the pandemic, but as Mr. Piles said, how does the pandemic prevent you from sending something you sent regular mail? How does it prevent you by doing it in compliance with the statute certified or registered mail? I can tell you, taking a poll of the board members to see how they would like service, that opportunity is not afforded in the election code. The election code's clear, state statute or case law is clear. I would hope that Your Honor would not fall for the red herring here, which they're just looking for cover to cover up, quite frankly, a fatal mistake that they made in bringing this proceeding. Court lacks subject matter jurisdiction, and on behalf of the board, we'd ask that the case be dismissed with prejudice.
All right, so I've heard the arguments of the parties, and we've had an opportunity to consider their briefs and their authorities on the case. I'm mindful of the fact, first of all, I guess my oath as a judge is to uphold the laws of the state of Illinois. And oftentimes, as we hear, there's some technical disagreement about exactly what that is. I certainly want to acknowledge that pandemic crisis that we're facing has put an awful lot of extra burden, I think, on everybody as far as conducting business, whether it's legal or otherwise, and it made life, just generally speaking, very much more difficult. I appreciate that fact. We have, I think, through the administrative orders that Judge Shainstead has signed, and kind of bent over backwards to make things as, I shouldn't say loose, but as functional as possible, still trying to achieve the ultimate goal without really sacrificing anybody's rights. All that being said, the election code, as I understand it, reading the cases, it is a situation where strict compliance with the statutory requirements is the interpretation, generally speaking, given, I would say, by the courts in trying to enforce these provisions. With regards to this litigation, there's a 5-day requirement for filing the petition. There's a specific description of what you've got to say in the petition in order to make it sufficient in terms of reversing the decision of the electoral board. These are specific requirements. The requirement of certified or registered name goes along with it. Sometimes it seems to me that in terms of administrative review proceedings and specialized litigation of this sort, where statutes spell out the steps, it sometimes seems like the old game of Mother May I, where if you miss a minor step, you lose the game. Sometimes I oftentimes feel that that's rather arbitrary and unfair, but nonetheless, that's the type of interpretation we're often required to give these very specific requirements. I can't ignore the fact that it requires that and it wasn't done. It doesn't seem to me that the requirement is overcome necessarily by question of actual notice. I think that, were we talking about jurisdiction in terms of the sense of having the authority to hold a person through a court decision, whether in person or an entity, the rules on service in terms of serving people personally or corporate entities through their registered agents, that sort of thing, we haven't relaxed any of those in the days of COVID, and I think the general purpose of those requirements under the Civil Practice Act, again, they're to assure that notice is actually achieved to the best possible means. But we're talking about a rather different subject matter here in terms of subject matter jurisdiction of the court. And when I have the power under the law to make a ruling with regards to a particular topic, it's not a question so much of people being adequately and properly notified. It's a question of whether or not the substance that is brought to me is done so with the proper requirements being fulfilled. And it hasn't been done here. I think that it is a very technical requirement. There may be not the best logic behind it. My obligation is to strictly follow the requirements of the code as the legislature has set forth here. So I find that I do not have subject matter jurisdiction of the case. It'll be dismissed. All right. Mr. Piles, you prepare an order.
I will prepare an order, Judge. I will send it around and I will e-file it.
Right.
Judge, just for clarity, that that dismissal is with prejudice?
It's with prejudice. It's a final and appealable order, I guess. Yes, it is final and appealable. I don't think I would file a motion to reconsider, but it's my decision and I'm sticking with it, okay?
Thank you, Your Honor.
Thank you, Judge.